back on this day, the 28th of October, as we resume our hearing. Let me welcome the members, both here at M46 and on the virtual platform. Let me welcome the public protector here at M46. I welcome and recognize evidence leaders, advocates Bawa and Mayosi. I welcome members of the media with us, our entire support staff and team in their various roles, and members of the public in their various platforms. Welcome, colleagues. Yesterday we adjourned on the note that given what would have happened on the latter part of the day, on the note that myself as a chair and the team would retreat a bit and then come back today having retreated and indicate how we proceed. And so we would have had brief interactions between myself, the public protector, and evidence leaders verbally here, but also through correspondence overnight, just to indicate that we were working as part of your instruction for us to look at certain things, and would have exchanged correspondences on different issues. And so today, as we start, colleagues, we're going to share firstly the correspondence that would have received overnight from the PP, and I'm going to invite the PP to speak to that correspondence on record for everybody else to understand the kind of issues that she would have considered. And thereafter, I'm going to invite our legal services team to talk to the committee. And thirdly, open the meeting to members of the committee based on what would have been shared with us by the public protector, as well as the guidance from the legal services. And then I would allow members to engage with that. So thank you very much for your attention in that regard. Again, welcome PP to today's session. I would have received, as we discussed, very late at night, your correspondence, placing on record certain matters about what would have happened yesterday and what your thinking is going forward. And I think it would be fair that as the PP takes the platform, that we're also able to fly to that. Tsepo. Over to you, public protector.
Maybe Tsepo, let me just send you, I should have, because then there's an opening which I have, though this is part
I'll
of
take a minute of pause, and then so that you're able to do that. It's so that it's done, we're able to follow you. So just 2 minutes, colleagues. It will also help me to grab a coffee. Thank you. Thank you very much for your patience for that. Over to you, Public Protector.
Thank you, Chairperson. Good morning, everyone, honorable members.
If you can, I know it's awkward. Maybe you can push the bottle so that you find a way to have the mic a bit. Yeah, that might also assist.
Am I audible?
I can hear you here. Can you hear on the virtual platform?
Very clear, Chairperson.
Okay.
I think it's fine now.
Proceed.
Thank you, Honorable Chairperson, honorable members. Thank you for affording me this opportunity. I sent an email, yes, indeed. And this morning I said, let me just, when you said I must come and be here to clarify. Yesterday, my legal team referred you to the statements repeatedly made as follows. Firstly, my attorney's letter to the committee via the chairperson dated 21 October 2022, in which it was indicated that the only issue which they were prepared to deal with yesterday was postponement application. Secondly, in the application which was delivered to the committee on Monday, 24th of October, reiterating that the right of this committee to sit as presently constituted was recognized only for the purpose of the application. And thirdly, during the oral presentation of the application. So the legal team pleaded with the committee to engage, in fact, and negotiate how to handle the matter forward. All this was ignored or rejected as you decided, Chairperson. So in doing so, you read out the decision immediately after your deliberations. And this development, we thought possibly you would go consider our inputs, but it was something which you were ready to deliver immediately when you decided. Maybe then after receiving our papers on Monday. So following yesterday's events, I then telephonically contacted the director of my current legal firm, Sianego Attorneys, and he confirmed that he will be in a position to consult with me on Monday or Tuesday next week. And the future participation of my current counsel team will be clarified once I have had a formal audience with them following the meeting with my attorney. After these meetings, I will be able to give a more informed indication on the way forward as far as the question of my legal representation is concerned, hopefully by no later than the end of next week, or maybe possibly Monday, the following week. I therefore request that I be given time and space to deal with the situation and thereafter communicate the outcome of my discussions with my current legal team, and failing which, and only as a matter of last resort, to seek the services of a new legal team, as I indicated yesterday. And I remain committed to cooperating with the committee whilst protecting all my rights as provided for in the rules and the Constitution. And I look forward to the engagement with and guidance from the chairperson. So I then also pleaded with I'm pleading with the committee to give proper effect to this issue. And as it was the decision of the Constitutional Court in February 2022, and whether I will succeed to convince my counsel, we will have to deal with it. I think there's records which I indicated yesterday, how the counsel indicated that for the meeting yesterday, that's what they were meant to deal with. So it was a consent as well, Chairperson, yesterday when I was addressing, when some of the members of the committee were just laughing as if we are not addressing a serious matter, and I think all of us would want to proceed with the matter as expeditiously as possible. So I'm not in the position to participate for now because of the absence of my legal representation. So, and at this stage, I elect not to say any other thing outside of this document or out of this information which I've shared now. So unfortunately, I just drafted this agently so that I can share with the committee. Thank you.
Thank you, Public Protector. Just before I go to members, as I indicated, I'm going to ask Ms. Fatima Ibrahim to come in and then thereafter invite members for whether there's clarity seeking questions or any other contributions they want to make, having listened to what the Public Protector has said and our legal services. Ms. Ibrahim.
Thank you and good morning, Chair, Public Protector and members. Chair, the process remains unprecedented. But as I've been saying from the beginning, it's underpinned by procedural fairness and rationality, yet with no blueprint. I've tried my best when called upon to do so to give guidance based on how these requirements should be applied. I give my advice today to the committee in good faith, having in the very short time I've had to best try and weigh up the legal consequences and options available to the committee. However, as novel as this process is, in rendering my advice, I do so with reference to what I believe to be accepted and binding legal authority. Also, in trying to guide the committee chair, I had to take stock, as the committee must also do today, of the context and the facts that gave rise to what transpired here yesterday afternoon. I don't believe that the decision of the PP's team should be considered in isolation or as an isolated event and separate from other things that have unfolded before this committee to date. As such, I wish to bring the following to the committee's attention, much of which the committee would know as it forms part of the correspondence that is before the committee. Advocate Mpofu came to the committee yesterday, making it clear that in his view, the application for adjournment was going to be refused. He said it would be no surprise. When members were posing their clarifying questions to the PP's legal team, the Honourable Sukas noted a concern in respect of the adjournment application that the PP may withdraw from the committee's proceedings. In response, Advocate Mpofu confirmed that the PP would not be withdrawing from the Section 194 committee. He did not indicate that council had been instructed to withdraw by Sianego in the event that that application would fail. The committee deliberated upon the application and decided not to grant the adjournment. Once the chairperson communicated this decision, Advocate Mpofu announced that his mandate did not extend beyond pursuing the adjournment application before the committee, and that it was not permissible for him to address the committee beyond that application, because to engage further would be to participate in what he termed illegal proceedings. Advocate Mpofu, Advocate Shabalala, and Advocate Matlapi then walked out of the committee, as did the Associate Attorney from Sianego Attorneys, Ms. Patel, who are the instructing attorneys on a record in this matter for the PP. It has every appearance that their mandate to represent the PP in the process to all intents and purposes appears to have been withdrawn. If so, by Sianego without any instruction from the PP, given that Advocate Mpofu indicated that he had no mandate moving beyond the application, having been engaged to represent the PP for the Section 194 inquiry, and the PP not knowing what was going to happen. As the PP informed the committee, she did not instruct her legal team to withdraw. I note this in the context of the correspondence that ensued in the days before between Sianego and the chair, leading up to what transpired yesterday. And I can only presume that they were acting on the instructions of the PP when these were sent to the PP. So I can inform the committee as follows. There were two letters on 18th of October. In the first, it was stated by Sianego on behalf of the PP. We further demand that the Section 1941 inquiry ought properly not to proceed as currently composed until the outcome of the proposed review proceedings, that being the review for the recusal. In the event, notwithstanding the above, the committee nevertheless decides to convene a sitting to deal with the issues raised herein or any other issue, then kindly give us at least 1 week's notice thereof so that the necessary preparations and all logistical traveling arrangements can be made, including securing the cooperation and assistance of the Office of the Public Protector. During that period, and I emphasize here, during that period, consideration will also be given to the legal options available to our client. So the PP ought to answer to the committee whether that occurred, that discussion on those legal options. In the second letter, also dated 18th of October, following an indication that this committee indeed intended to sit on the 20th, Senejo indicated that the PP and her legal team were not in a position to attend committee hearings on the 20th of October and sought an extension. The chair granted this. That letter further stated, even then, it is our intention to attend for the purposes of making an application for the adjournment of the inquiry pending the envisaged court challenge. Depending on the outcome of that application, notice of which is hereby duly given, we would be available to make realistic and practical arrangements for the way forward at that stage. Given this response, in a letter dated 19th October, the chair responded and indicated that it appeared from the second letter that the PP and her legal team would be in a position to meaningfully participate in the inquiry by the end of this week. We stated further in that letter, there is accordingly no reason why your client's legal team should not be ready to proceed with a cross-examination of Mr. Jani and Mr. van der Merwe, given that they've had more than adequate time since then to prepare. I note that Advocate Mpofu has previously indicated that he would not need more than an hour with Mr. Jani. In any event, your client ought to have been aware that after a decision in relation to the recusal application, the hearings would resume and a legal team would have to be prepared to continue. It is noted from media reports that the Public Protector's legal team was able to launch 3 further court applications during that month alone. It also appears from your letter that your client's legal team is using the time taken by myself, that being the chair, for consideration of the recusal application to conduct other work and failing to prepare for the committee proceedings. It therefore appears to be of their own making that the legal team is not ready to proceed and deal with the 2 witnesses that have now on more than one occasion been rescheduled. It is reasonable to assume that since the committee has not been sitting since 21 September, your client has had the time previously requested to line up her witnesses. Further, the Public Protector's stated intent to institute legal proceedings in respect of the recusal should not delay the committee's work in the absence of a committee decision to postpone hearings or a court interdict preventing the committee from proceeding. So that was all made very clear in the correspondence. But more importantly, Chair, the letter stated, in the event that the committee determines that it will proceed notwithstanding the adjournment application, the hearing will resume with either Mr. Jani or Mr. van der Merwe, as the case may be. You are hereby given notice that you should be in a position to deal with either witness on the 27th of October, being yesterday. The leading of evidence in respect of Mr. van der Merwe will be done either by Advocate Bauer, if the committee does not support the call for her recusal, or she does not recuse herself, or by Advocate Mayosi, as the case may be. At that stage, we were dealing with the recusal application of Advocate Bauer. Accordingly, please treat this correspondence as notice, as per your request, that the committee will resume its hearings on Thursday, 27th of October, unless the committee, having considered the adjournment application, determines otherwise, and you are given notice now to be prepared to deal with either or both outstanding witnesses on that day and the following day, Friday, 28th October. This is being today. Also, please ensure that you file the affidavits of your client's witnesses that you have completed thus far by no later than 21 October, and also confirm the number of witnesses that have been secured today. We trust that this accommodation of your request to be afforded more time is in order. The PP chair was hence given notice that the matter was proceeding with the witness after the postponement hearing in the event that that adjournment was not granted yesterday. There was no surprise in that. A further day was even granted specifically to allow the PP's legal team to prepare for that eventuality, given that they were in court on Tuesday this week. Hence, we did not sit on Wednesday. It then begs the question, Chair, as to why the same legal team that had been instructed and on brief for the entire Section 194 proceedings, both in this committee and in the litigation, would have that mandate retracted and then only be given a limited mandate to deal with the adjournment application. In fact, on behalf of the PP, Senejo responded to our letter of 21 October, making it clear that any conclusion that the legal team is not ready to proceed and deal with the 2 witnesses was misconceived. Further, they said that the issue of witnesses obviously and clearly depends on which way forward, if any, will be followed, and further took issue with the chair's tone of the letter, indicating that it was an accusatory tone and that the letter contained a false accusation of the alleged unpreparedness of counsel. On the contrary, and for your information, Mr. Sianechel then indicated we are very much prepared. So all indications were that all systems were ready to go at this point, regardless of the outcome of that application. Bearing in mind that we did receive notice that there would in the background be the review proceedings. So Chair, it begs the further question, what changed? And Advocate Mpofu was aware of these letters, and in fact, he referred to the letters in passing yesterday. So clarity must be obtained from the PP, having now discussed the matter with Mr. Sianechel last night, as to how between Friday, 21st of October, and yesterday, the PP's legal team got stripped of their mandates without her knowledge. At least for the sake of the record, and given that this committee has an oversight function, the PP should clearly be on record and asked to explain the aforegoing change of heart, if such occurred, when it occurred, if she in any way retracted or narrowed the mandate, and if she did not do so, who precisely did so, and on what basis this was done without her knowledge and her instruction, given that the letters reflected a willingness to proceed even if the application was not granted. This is particularly so as Advocate Mpofu has placed on a record in the written application that they knew the outcome of the application, and he said as much, that they were sure it would not be favorable. And yet, contrary to the above-mentioned correspondence and espousing view that they had made, there was no indication whatsoever in the correspondence or even in the oral submissions yesterday that they were not ready, or that if it would come to the stage that it reached yesterday, that the legal team would no longer be mandated to continue, or that their brief would somehow now suddenly come to an end. Indeed, the claims that they could not participate in the legal proceedings of the committee have been raised as early as day one, when it was made clearly that the PP's legal team was representing her before this committee, and that the PP was attending under protest because they believed that this process was unlawful. This is not a new position that has now arisen that would have necessitated a walkout. If anything, this was the position that they adopted from day one. Chair, coming to some of the legal issues. In terms of challenging a recusal application, as a matter of law, when a recusal application is refused, the committee's proceedings do not suddenly become an illegality such that the legal team could not continue their participation. The usual route to follow, the reasonable route to follow, if a recusal application is refused, is for the tribunal to conclude its work entirely, and then if necessary, for all the decisions of that tribunal, including the refusal of the recusal application and any other objections, to be challenged collectively in review proceedings. The PP is entirely within her rights to review the Section 19 process in the event that the House resolves to remove her. The Supreme Court of Appeal, Chair, explains in a case called the Take and Save case that an appeal in medias res, meaning an appeal in the middle of ongoing proceedings, in the event of a refusal to recuse, although legally permissible, is not available as a matter of right, and it is usually not the route to follow, because the balance of convenience, more often than not, requires that the case be brought to a conclusion at the first level, and that the whole case then be appealed, meaning that you deal with all your objections and all of your grounds of review and not deal with matters piecemeal. The Take and Save case was a civil trial. It regarded a dispute on monies owed by an individual and his sureties to a bank. The evidence of the witnesses reached a crucial stage in that case, and the defendant's legal team then suddenly withdrew without reasons. The defendant then represented himself and applied for a postponement. The trial judge debated the merits and was concerned that the postponement application was nothing but a tactical move to gain time. Nonetheless, the judge granted the postponement. The defendant then obtained new counsel, who then applied for the judge's recusal. The judge refused the recusal, and that recusal decision went on appeal to the Supreme Court of Appeal. The case is useful because of the comments on the postponement and the comments made by the SCA on the issue relating to the withdrawal of legal counsel. This court stated that the presiding officer cannot be supine, in other words, cannot lie on his back. He must actively manage the proceedings to ensure control and avoid the waste of resources. The SCA further said
Chair, on a point of order, Chair.
Yes, what's the point of order?
Yeah, can we be given the document that the lady is reading? Because we want to follow properly. It's very difficult to follow now that she's got a document we can't see, we don't have.
Firstly, the lady is Miss Fatima Ibrahim, is our legal services. So you want what she's going through to be flighted?
Yes, or to be even emailed to us. Is it a
Or
secret?
it will be forwarded to the members.
Yeah, Chair, at the moment, these are my speaking notes.
Yes.
As I always prepare, which are my own personal notes. The presiding officer cannot be supine, i.e. lie on his back. He must actively manage the proceedings to ensure control and avoid the waste of resources. The SCA further said, and I quote, "It is one of the oldest tricks in the book when a party gets into a legal difficulty for the legal team to withdraw or to have its mandate withdrawn so as to engineer postponement because the party would then not have legal representation. However, this trick, the court went on to say, should be rejected, and in appropriate circumstances, the postponement should be refused. Mere withdrawal by a practitioner or the mere termination of a mandate does not, contrary to popular belief, entitle a party to a postponement as of a right." The SCA then moved on to consider the defendant's act in appealing the decision not to recuse while the trial was ongoing and evidence still had to be led. And here, as I mentioned earlier, the court said that to do so in the middle of a process, although legally permissible, is not always the correct route to follow, and that the balance of convenience would more often than not favor that it be brought at the conclusion of the matter. So the SCA was clearly of the view that the proper course of action was to wait to challenge the refusal to recuse until the end of proceedings. And then on the recusal application, the court also concluded that the conduct complained of would never found a well-informed or reasonable apprehension of bias. So the appeal was dismissed and the decision not to recuse was confirmed. The trial would have then continued in the High Court. The SCA relied on the Constitutional Court's decision in Sakawa, where it had been explained that a refusal of a recusal application should not be immediately challenged in a higher court. Instead, the first stage proceedings should be concluded in their entirety, and only then should the bias issue, along with any other issues, be raised so as to avoid the courts being inundated with multiple applications in respect of the same process. The court said an applicant for recusal cannot be said to be entitled to prosecute an appeal immediately. Two considerations suggest the contrary. First, though there is some early authority that a decision by an applicant for recusal to proceed with the merits of the matter, instead of insisting on challenging the refusal to recuse by way of appeal, may constitute a waiver of the recusal objection, it is clear from subsequent authority that waiver in these circumstances only occurs if it is unambiguous. The recusal point, unless so abandoned, therefore remains good for a later appeal. There can accordingly be no question of an entitlement to proceed immediately. And I mentioned this yesterday, Chair, nothing prevents the public protector from dealing with the recusal at a more appropriate time. Second, a court that has dismissed a challenge to its composition has ruled that it is properly constituted. In these circumstances, the Labour Appeal Court had the power to regulate its own proceedings, including the power to direct that the party whose challenge has been dismissed should proceed with the merits of the matter before it. Generally, considerations point strongly against piecemeal appeals, though the matters remain overridingly one of convenience. Whether a court that has dismissed a recusal application permits the applicants to bring appeal proceedings first will depend on a range of factors. These include the nature of the matter, the nature of the objection to the court's composition, the prospects of success in the recusal, and in the case of an appellate court, the length of the record. The decision on these factors lies with the court itself. The applicants were therefore not entitled to proceed as of right with the application for leave to appeal. So the fact, Chair, that Advocate Mpofu believes that the recusal applications were wrongly dismissed or the postponement was refused on a basis that was not valid are in and of itself not sufficient reasons for the PP's legal team to cease participating in these proceedings. This has been confirmed by the Constitutional Court and the SCA. The committee paid heed to the various interlocutory type applications and objections that have been raised since the motion was adopted, and in these proceedings in particular. All of these have had the effect of delaying and drawing out proceedings far beyond what would be a reasonable timeframe for the conclusion of this important work. And no doubt every failed application and objection will, if it comes to that, find its way in review proceedings and be dealt with appropriately at that time by the courts. But to insist to do so now is, in our view, premature, and it frustrates parliaments in our fulfilling of an important constitutional obligation, which can only be fulfilled, as I said yesterday, prior to the PP's term expiring. There can be little doubt that if the committee were to now delay its work, the work would not be completed before the PP's term comes to an end. On the issue of the withdrawal of the legal representatives, this invariably provides scope for the seeking of a postponement, but it's not simply there for the asking and granting. The termination of a legal representative's mandate or their withdrawal has been recognized, as I've indicated, by the Supreme Court of Appeal as being one of the oldest tricks in the book to engineer a postponement. The settled legal position is that such termination or withdrawal does not, in fact, entitle a party in question to an automatic postponement. In this regard, the SCA explained the approach as follows. A supine approach towards litigation by judicial officers is not justifiable either in terms of the fair trial requirement or in the context of resources. One of the oldest tricks in the book is the practice of some legal practitioners, whenever the shoe pinches, to withdraw from the case, and more often than not to reappear at a later stage, or of clients to terminate the mandate, more often than not at the suggestion of the practitioner, to force the court to grant a postponement because the party is then unrepresented. Judicial officers have a duty to the court system, their colleagues, the public, and the parties to ensure that this abuse is curbed by, in suitable cases, refusing a postponement. Mere withdrawal by a practitioner or the mere termination of a mandate does not, contrary to popular belief, entitle a party to a postponement as of a right. Chair, there can be no doubt in the similarities between a court and parliament, as far as parliament too owes a duty to the public and is exercising a public function here in the interest of the public with public funds and public resources. Indeed, in ensuring that the process is fair, regard must be had to what such unfairness entails as far as our witnesses are concerned and the public on behalf of which members are mandated to act. This is especially so given the timing of the withdrawal, the apparent lack of knowledge of the PP as to the mandate being removed, together with Advocate Mpofu's unwillingness to indicate where the mandate arises from, who gave it, and when precisely it was given. It may well be that it was done precisely to seek the very postponement that the committee refused. I unfortunately don't have the facts to support that. The committee was scheduled, nevertheless, to continue its hearings today with the witness. It was made clear, as I said in both the correspondence and at the start of the proceedings yesterday, that if the adjournment application failed, the process would unfold with the cross-examination of Mr. Jani and the leading of evidence of Mr. van der Merwe, a witness whose appearance has now been delayed for some weeks, despite the evidence leaders apparently being ready to proceed. And members would have seen Mr. Jani was in the meeting the whole of yesterday. It appears that the PP is now requesting a postponement, but on the grounds of lack of legal representation, and to persuade the legal team to return, or worst case, to get new legal representation. It's unclear what the cost implications thereof would be to the public purse. The PP has indicated that she can only consult with her legal representatives on Monday and Tuesday, and seeks to revert to the committee by 7th of November, if I understood correctly. That is some 10 days later. There is nothing before this committee to indicate what these 10 days are required for and what the reason for the delay is. It is hard to believe that it would take this amount of time for her to confer with her legal team. In order to adjudicate this postponement application, the committee will have to now interrogate a number of issues in determining how to proceed, including what mandate the PP gave her legal team on the 27th of October, bearing in mind that they had been well notified to continue with the examination of Mr. Jani and that we were proceeding with Mr. van der Merwe, and had indicated that they were ready to proceed. whether the PP instructed her legal team to now withdraw from the committee's proceedings yesterday in the event that the adjournment application was dismissed, or whether her attorney acted out of his own and the impact thereof. Because one would think that if that was the intention, or if that was the request of the PP, that such should have been included in those submissions itself. Whether Advocate Mpofu, Advocate Shabalala, and Advocate Matlape are still representing the PP in the mooted review application and other litigation related to this 194 process, but not in the committee's proceedings. Chair, right now, I'm not clear as to what the position is in respect of those review proceedings. We were told that we would be served with papers fairly shortly. It is unclear whether that is still the case and whether Advocate Mpofu is still on brief in respect of that portion of the matter. As the PP indicated, she did not instruct the team to withdraw from the proceedings in the event of the adjournment. Then that begs the question, did they withdraw to force a postponement to undermine the very decision that the committee had taken yesterday after careful consideration? Given that the legal team expressly anticipated the adjournment being dismissed, what did the PP then anticipate doing in the dismissal? Surely one can assume that the scenario would have been discussed at length, and in fact the correspondent indicated that consideration thereto was given. We're now told by the PP in effect that she was not privy to these conversations, notwithstanding that they act on her behalf. It would appear that there are no answers, Chair, to some of the above, and the PP is now requesting time to consult, presumably on all the issues that I'm raising. This then leaves the committee in a very difficult position, where its decision of yesterday is being undermined. For the reasons outlined, though, Chair, with reference to the take and save case, the committee can now decide to what extent it will allow this development to scupper proceedings. The Constitutional Court directed that the rule on legal assistance be read as follows. The committee must afford the holder of public office the right to be heard in his or her own defense and to be assisted by a legal practitioner or other expert of his or her choice. Legal representation is not an absolute right, and we must give consideration to what the full meaning is in the context of this committee. The court had specifically noted that members may ask questions of the PP directly, even when she's not giving evidence at the time, and that the legal representative would not be allowed to give evidence on behalf of the office bearer. These are all part of our ordinary oversight processes, and as I said yesterday, this is the ultimate oversight process, and we mustn't lose sight of that. Whilst there's no question, therefore, that the PP is entitled to her legal representation, and in fact, I've advised that the chair take whatever necessary steps to ensure that the PPSA cooperates in securing this legal representation. And in fact, we've done so, and the PPSA have played their part. One cannot ignore the context in which this issue has now arisen and the timing. I do not, in bringing this to the attention of the committee, cast aspersions on the PP or her legal team or their bona fides. It's not my place to do so. But Chair, I must reiterate my concerns that I raised yesterday about the committee being duty-bound to perform its constitutional functions. This remains real and valid, and those functions, as I said, have to be performed timeously. The committee can, I believe, do a number of things going forward, which would still be procedurally fair and meet the standards of rationality. The first option would be for the committee to continue if it takes the view that it was simply a ploy to force a postponement. In other words, if it takes the approach adopted in the take and save dicta of the SCA, and allow the evidence leaders to continue with the evidence in chief of Mr. van der Merwe today, followed by questions from members. The PP can then elect whether she will cross-examine or engage other legal representatives to cross-examine Mr. van der Merwe at a later date. This option will allow the evidence leaders to wrap up the witness for whom they have obtained oral evidence and in the interim start with the preparatory work necessary in respect of putting questions to the PP, who has indicated that she's keen to give her versions of the event. I do not believe that this would be prejudicial to the PP because such evidence in chief happens in a public setting, and her team, whether it's going to be the existing team that will return or her new team, will still be afforded the time to cross-examine and to deal with the evidence should the PP wish them to do so. She can also be afforded the opportunity to respond herself if she so wishes. This at least allows some of the important work of the committee to continue and does not render the committee immediately incapacitated. It also means that if Advocate Mpofu returns and again insists that he wants a certain time period from the last witness before he's prepared to lead any other witness, then this last witness has already been led. The second option is to agree to allow the PP a short time to get feedback and report back to the committee, preferably by close of business on Monday, after which the evidence of Mr. van der Merwe will be led, knowing that the committee intends to proceed. And what I've said in relation to the first option would equally apply. The benefit of this option is that we're giving the PP herself some advanced notice. Third would be to allow her the time and space as sought to negotiate with her team, to return or finding a new team via the PPSA and communicate this to us by the 7th of November or earlier if she's able, as per her request made this morning. At which stage the way forward becomes a little clearer, as court applications, if they are still going to be launched, would most likely have been launched by then. This option, though, will inevitably lead to a longer delay and would be tantamount in essence to granting a postponement, albeit on different grounds, that was previously refused, no matter how dressed up it now is. If the feedback is that there is a new team, the suggestion of allowing the evidence leaders to then at that stage continue with Mr. van der Merwe is still a possibility if the committee agrees, though in all likelihood that will be vigorously opposed by any new team asking for further postponements. In my assessments, this leads to the likelihood of the committee not sitting this year. The fourth option is to say to the PP, you have until a set date and time to sort out the issues that you now find yourself with and to then report back. Depending on whether there is a new team, additional time be granted to that team to familiarize itself with the record before reconvening. Chair, yeah, I'm going to pause to remind the committee that the evidence of the panel alone was over 11,000 pages. That excludes all the evidence submitted in the process to date. It includes all the transcripts and the hours and hours of proceedings that have already occurred. This could conceivably take months and will likely only allow for a resumption of proceedings, perhaps by mid-year next year. In respect of these options above, the committee can also seek external advice on how to proceed if the PP's team does not return and what the impact of her procuring a new team will be on the process to date. This opinion can be sought urgently, notwithstanding the committee exercising any of the other options that I've discussed. Chair, that is as best I can do under the short time frame that I've had to deal with the matter, but I leave it to members to deliberate. And of course, for the PP to be given an opportunity to respond to anything that I may have said.
Thank you, Ms. Ibrahim. I'm now going to invite the members to interact with the PP's presentation and as well as the legal advice guidance given to us as a committee. I want to note the following members: Honorable Lothrit, followed by Honorable Melder. I'm still noting for now. Honorable Ngosi. Do I have any further hands? Honorable Nodada. Sungula. In that order.
Chair, my hand is up.
I see all the hand. Thank you, colleagues. Maybe before I proceed with you, I see the hand of Advocate Bauer.
Chair, I don't have a question. I just want to raise a point of clarity in something that was raised in relation to the evidence leaders yesterday. It was put to the committee that the evidence leaders is not entitled to ask the public protector any questions. That is not correct in terms of the terms of reference and the directives. I don't have a question to ask. I simply want to set the record straight.
Yeah, that's fine. Thank you. I will also respond to that later on, perhaps not now. Honorable Lothridge.
Thank you very much, Chairperson. Thank you also for the presentations by the Public Protector as well as Ms. Ibrahim. Chairperson, I think it is important that we focus on our own rules, section 129AD3, as Ms. Ibrahim has referred to, in that the committee must afford the holder of a public office the right to be heard in his or her defense and to be assisted by a legal practitioner or other expert of his or her choice. But however, Chairperson, as pointed out, this does not mean that the section 194 committee proceedings cannot proceed where the public protector does not have a lawyer present. It only means that the public protector has the right to choose a lawyer and have him or her assist her. Now, this is much the same in our courts, Chairperson, where accused persons in criminal trials and parties in civil proceedings also have the right to legal representation, but that doesn't mean that the courts cannot proceed without such lawyers being present. And in appropriate circumstances, in fact, the court can proceed with the hearings without these lawyers being present. And this frequently does happen in our courts. Our courts have also warned to the right to legal representation that it doesn't entitle, as Ms. Ibrahim pointed out, in the particular case, the taken safe trading case, that you are entitled to a postponement merely because you don't have legal representatives, and especially if they withdraw at the last minute. And I think it's very important that the taken safe trading is referred to, and the specific part of that judgment is very appropriate for our proceedings here. Now, in this case, Chairperson, it's difficult to understand on what proper basis Advocate Mkabane's lawyers could have withdrawn. We don't really know. No proper explanation was given, and those are the questions we have answered. And the attorneys and counsel for Advocate Mkabane owes this committee a proper explanation. And underscoring this, in the letter of 21 October, CNAGO attorneys recognized that the adjournee application would be heard on the 27th of October, and then vigorously denied that the legal team and counsel were not ready to deal with the next two witnesses. Now, Chair, if this was truly the case, that the mandate of the legal team only extended to dealing with the adjournment application, that point should have been made then. So I'm very concerned that what appears to have happened is that when the adjournment application was refused by this committee, the legal team then withdrew in an effort to secure Advocate Mkabane the postponement that had already been refused by the committee. And this is what Ms. Ibrahim referred to in the SCA case, which is described as the oldest trick in the book, and an abuse which should be curbed by refusing a postponement. So, Chairperson, in the circumstances, it seems to me that the committee should refuse the postponement, or at the very least, as was proposed as one of the options, grant it only for a very brief period, perhaps the very latest Monday afternoon at close of business. Anything else, Chairperson, would be at odds with the duty of this committee to expeditiously and efficiently proceed with and conclude these proceedings. Thank you, Chairperson.
Thank you, Honorable Lothridge, for your contribution. And now recognize Honorable Melder.
Good morning, Chairperson, and good morning, colleagues. I would like to start off to thank the Public Protector for the input that she gave this morning from her perspective, as well as the legal input and the advice given by Ms. Ibrahim. And I think that is that specific issues that they dealt with, and the case law is very helpful, and I think it's very relevant. Chairperson, you'll recall that on the first sitting day of this process, months ago, after I've listened to Mr. Mpofu on that day, I said that it's clear to me that the intention is to keep us busy until the expiring of the Public Protector's term. At the time, Mr. Mpofu took a very strong objection that I could say something like that. And as we proceed, I'm slowly but surely obviously getting the idea that I was absolutely right. Now, the legal team indicated to us there are some options that we need to consider. There's 4 options spelled out. The problem is this. At the moment, I think we first need an answer from the Public Protector herself. She is the client. She is the person that gave a mandate to her legal team. They cannot revoke the mandate by themselves. They are there in terms of practicing lawyers and practicing attorneys and to keep up the profession, to act on behalf of the instructions of their client. Now, it seems there's a problem. The client indicates to us that she did not give such an instruction or ended their mandate. This is something that needs then to be investigated, because this institution of Parliament cannot be held ransom by legal people, legal representatives who have other agendas. In the first instance, I cannot see why there was any need for even an application for an extension or for a postponement. Some weeks have gone by where the legal team of the Public Protector had time to prepare and to be ready to proceed. Mr. Mpofu found 3 hours, almost 3 hours this week, to attend a press conference, not in the audience, but as part of the presentation. So he had more than enough time to be prepared and to be ready to proceed. I've got my views in terms of the 4 options, and I would like to come back to that. But I think, first of all, we need a clear and direct answer from the Public Protector now, whether she gave an instruction to end that mandate. And once we've got that answer, we can proceed. Thank you, Chairperson.
Thank you, Honorable Melder. Honorable Ngosi.
Thank you, Chairperson, and I acknowledge the Public Protector and members of the committee. Chair, I think that I'm going to combine a proposal with comments on what the Public Protector has said. Firstly, I note the input made by our legal advisors and take into consideration the inputs that they made and the suggestions therein. I heard the Public Protector say, Chair, that after we had, or you had, the application for adjournment, you then ignored the request. I just want to clarify that this committee did not ignore the request. This committee deliberated quite extensively on the request and motivated its decisions in any way to indicate that the chairperson has a discretion which he must exercise in terms of whether he accepts or rejects a request for adjournment. This is a discretion that lies entirely with him, advised by this committee, and I think we follow due process in rejecting that request. Chair, we were threatened with a court challenge yesterday. Advocate Mpofu extensively spoke, and he did warn us that if for each and every sentence he will say he will go to court if we refuse. Instead of going to court or readying himself or implementing his 40% of his 60% readiness, he instead walked out in what seemed for me, Chairperson, a very pre-planned and staged walkout. Currently without the knowledge of the Public Protector until she clarifies whether she had given mandate for them to walk out. So there is a decision of the committee to proceed with the process and to consider the next steps in this process. And those have been outlined And I think that the public protector had been given an opportunity to address processes within this committee, to clarify them and to exercise a right, and also processes outside of this proceedings, as he has done through going to court. This is an indulgence that has been given to the public protector extensively. However, Chair, the indulgence is not inexhaustible. And I think that for now, the committee is satisfied that we have afforded the public protector enough opportunity to address whatever she wanted to address, both inside and without. We will not tire to continue to give her this opportunity to do so wherever she needs, whenever she needs clarity, but this is not inexhaustible. There must come a time when we call on her to take this process seriously. And therefore, Chairperson, may I suggest then that we do the following. We will allow the public protector the opportunity to consult with her legal team and or seek a new legal team. And in doing so, we implore her to note that time has now become of the essence in this committee. We run the risk of running this process outside of the reasonable time permitted by both the National Assembly and our own directives. And therefore, Chairperson, I say that the committee will continue on Tuesday. That is my proposal. I mean, the committee must continue on Tuesday, and that the public protector is given the opportunity to consult with legal representation from now, after adjournment, until Monday afternoon, and the committee resumes on Tuesday morning with hearing the last witnesses that appear, that are scheduled to address the committee or to give evidence to the committee. That is my proposal, Chairperson.
Thank you, Honorable Ngosi. Very clear proposal there. Honorable Nodada. Honorable Pauline Nodada. Is Nodada on the platform? Okay, I'll come back to him. Honorable Zungula.
Thank you, Chairperson. Greetings to the colleagues, members of parliament, members of the committee, the PP, and South Africans that are watching. Chairperson, let me start off by saying what happened yesterday was unprecedented. And it is my view that as it happened yesterday, we need time to reflect and make sure that whatever that the committee does, it is not done, we must not rush our processes. We must sit down to apply our minds, because the process is very important, Chairperson. Like I stated even yesterday, this process is the first ever inquiry of this nature. Therefore, it will set the tone for other processes, either in the next year or 50 years, and in the functioning of and the maturing of our democracy. Therefore, it's very important that we seek advice as much as possible from experts, from people that are not part and parcel of the proceedings in the committee. I note that the legal advice of Ms. Fatima Ibrahim is particularly one-sided because she's inherently part of the proceedings. Therefore, her advice will always take one particular direction for that reason. Now, we can't take her legal advice, Chairperson, is a gospel truth. We note and we understand, and it is public knowledge, that Parliament has lost cases in the past when those cases are adjudicated in the courts. And those cases, Parliament had been receiving advice from legal advisors within the institution that Parliament is on the right, but when we go to the courts, Parliament loses. Now, what I would propose that given the importance of this process to South Africans, the public protector, and the maturing of our democracy, let us not rush these processes and take emotive decisions. Let's first ascertain or get independent legal advice from people or institutions that are not part and parcel of these proceedings. That is the only way, Chairperson, in which you could get a sober view, a view that is less political, but more about the rights of the PP, justice, and fairness. That is my first proposal, Chairperson, that let us get that independent legal advice. Secondly, Chairperson, the process needs to be founded on the principles of justice and fairness and rights to legal representation. You'll remember, Chairperson, that the public protector had to fight, go to the courts, so that whatever happens in this process, at no stage must she not have legal representation. And even when the rules were actually set up for this particular inquiry, the rules were, in fact, the decisions that were taken by members of parliament was to ensure that the public protector does not have legal representation. It is only after the courts were approached and that the court ruled that indeed it would be a travesty to justice if she does not have legal representation. Now, what happened yesterday, I repeat, it was unprecedented, which is due to disputes which have been long time coming. We know that almost ever since the inquiry started, there have been disputes between yourself and members of the committee, between yourself and the legal representative of the public protector. And whenever there were disputes between us as members of the committee and yourself, we've always maintained that we need to approach a sober and independent person, such as the speaker from our side as the members of parliament. However, in the case of the legal representation of the public protector, their view would be to approach the courts because that is the best avenue from their perspective that would resolve these disputes. The disputes, Chairperson, are natural. People will always have disputes and the courts will always be approached to resolve those disputes. Now, I do not view it as threats that when a person is saying, I don't agree with you here, let us get the view of a court or let us get the court to resolve our disagreement is seen as a threat. Because remember, Chairperson, it is very important that in light of this process, there must not be one party that will feel aggrieved. There must not be one party that will feel as if their rights have been trampled on. That is why the courts become very important. Therefore, the courts are still to adjudicate and resolve some of these disputes. And it would be prudent for us to allow the courts to adjudicate and resolve some of these disputes so that when the processes moves forward, we know that it is a process that will not at the end, when the end, we're saying we're done with this particular process, the courts will be approached and the entire report that this committee will have to deliberate and to present in the National Assembly will be found wanting. And let me remind you, Chairperson, there's been a couple of reports when that have been adopted or agreed to by committees in Parliament and the National Assembly. And when those reports have been taken to the courts for scrutiny and adjudication, some of the reports were actually overturned and even to an extent whereby the Parliament has been found to have violated the Constitution in its work. That is why, Chairperson, I would propose that let us not rush the PP. The PP would have been, would have been surprised as much as we have been surprised. Therefore, let us allow the PP reasonable time to consult, ascertain the way forward, and come back to the committee. She will consult and make a determination whether to continue with the legal representative or seek new legal representatives, and then we take it from there. But we cannot, Chairperson, give a time that is unreasonable by saying by Monday. This is Friday, and chances are the deliberations of this committee might finish in the afternoon. Now, in the afternoon, we expect that a person must go and work throughout the weekends. We don't know their commitments. Also, the people that she needs to consult, we also don't know their commitments. Now, we are going to force her to take rash decisions because the deadline of the committee is Monday afternoon. That is time, that Monday afternoon time, Chairperson, it is unreasonable. So let us give her a reasonable amount of time because we want justice. We want this process to be fair. We do not want a process whereby everyone, the public protector has been compelled or forced to make urgent decisions because, the committee did not understand her position. Remember, Chairperson, this is an inquiry to determine the fitness. There's no guilt here. There's no one who is said to be unfit to hold office or anything of that nature. That's why I propose, and strongly propose, we need to be fair to the public protector because this is her reputation that is on the line. This is her career that is on the line. Therefore, she must do anything and everything in her power to salvage her reputation, her career. Now, by being forced to make decisions, over 1 or 2 days, decisions that would implicate her rest of her life, I think, Chairperson, would be unfair. As Ms. Fatima had stated, that just from the panel, there was over 11,000 pages. Now, obviously, there's so many things to consider for the public protector in terms of her moving forward and the way forward in this regard. That is why, Chairperson, I want to appeal that let us not create short turnaround times for the public protector because we are going to handicap her. Let us allow her reasonable amount of time. She's here, we could be asked what amount of time will she require to consult whoever that she needs to consult. And I can't imagine if she wants to, because part of the consultation will have to touch on the issues as to why did the legal representations stage a walkout? What are the requirements or what needs to happen for that legal representation to come back if they are still opening to come back and represent her? If she's going to, request for a new legal representation, again, she'll have to have the difficult task of ascertaining who is able to take on this particular case and try and catch up as much as possible so that they are able to continue doing the work of representing her. So, Chairperson, this is a very, very critical matter that does not need the committee to take unreasonable demands to the PP that by Monday afternoon she must report. I wanted to raise those issues. Thank you.
Thank you, Honorable Zungula. Honorable Jane Manani, sir.
Thank you, Chairperson. Good morning, colleagues, and let me greet everyone on the platform and as well on M46 and acknowledge the presence of the legal representative, Fatima, and one would want to actually welcome the presentation. And my first question is for her, I just want to check what are the implications with the withdrawal of yesterday. The question is for Ms. Fatima to just give clarity. And Chair, let me go straight to the issue of what we are discussing on. One wants to note that, I mean, yesterday we have deliberated on the issue of the adjournment or any postponement. So I would want to emphasize the fact that as this particular committee, we have agreed that we are continuing with the process. And one would want as well to indicate that actually yesterday, some of us, I felt that as the portfolio committee, we have been undermined. As Honorable Zungula says that it was an unprecedented incident that could have happened. One, it says that I would want to emphasize that actually it was unethical that as members of this particular parliament entrusted and been given mandate to actually play oversight and accountability. We have been undermined yesterday, and we hope that people are learning that it is difficult to actually make people to account when they have to. And we always like to pretend or emphasize that we're doing this on behalf of the society. So I hope that the society have noted that when we do this work, it is not easy. Some of us, we even forget ourselves along the way in terms of who we are because of things that we are exposed to, other people inciting others while they have to deal with issues, but dealing with personalities. Chair, I would want to say to the portfolio committee, I think we have actually exhausted all the opportunities of giving the public protector space to actually exercise her rights in terms of getting representation and everything. And so far, it shows that these are delaying tactics. And I think on her representation, for me, I don't understand why does she needs 10 days. For me, it is too much. And I would want to agree with what Honorable Becky could have said to say, at least let us get a sense by Monday or Tuesday in terms of what needs to happen moving forward, but with a view that as the committee, we are actually continuing with our process. And I think, Chairperson, it will be unfair for people to want to say that we are not reasonable. I mean, we've got terms of reference. We've got a program that we've been, chopping and changing it as it when there are pressing issues that needs to be amended. So we have agreed when we started that as there are pressing issues, that particular program will be changed. So there's nothing wrong about actually agreeing on specific timeframes, but going beyond your 7 November, it is too much. And it really shows that some of the people, more especially from the public protector side, they are not actually ready to make sure that we complete this particular matter. One would want to as well emphasize the fact that it is important that as we going through the process, we take note of what Fatima could have said, that we can go as well seek for legal advice. So that's what one would want to say. And Chair, as I conclude, I would want to say that next week, let us start continuing with other pending witnesses that needs to come forth. Thank you.
Thank you, Honorable Mananiso. Honorable Tolangwala.
Thank you, Chair. Thank you, Chair. Chair, let me start by echoing the views by my colleague in that let us welcome the submission by the public protector. Of course, we are in an unfortunate situation, all of us. But one part that I did not get, maybe it can be answered later on, not now, is the actual time frame. Was she kept on using Monday or that other Monday or a Tuesday and all that? So I did not actually capture the specific days and the specific time frame she needs. I think even the Parliamentary Legal Services said that's how they captured it. So if later on it can be maybe clarified. But I think in echoing the sentiments by my colleagues, we welcome the presentation, and equally, Chair, we welcome the advice by the Parliamentary Legal Services, and I want to say on record that I have confidence in their capabilities, in that they've taken us from the start of this inquiry until date, and they've guided us in terms of providing legal advice. Of course, Chair, none of us would have said legal advice is a gospel truth. There is no such a thing. In actual fact, to the contrary, we have agreed in this committee that advices are serving as advices. They are not decisions, but they are meant to capacitate us as committee members to arrive at a decision, having seen a number of aspects that which the advice is helping us on. So there is no such a thing as a gospel truth of an advice here. Chair, I want to reiterate that as per the resolution of the committee yesterday, that the inquiry must proceed. Now, the question that which we are posed with as the committee is, how do we then proceed with the inquiry? When and how is the evidence going to be led? And who is going to lead that evidence? And balance that, Chair, with justice and fairness. We must be fair to the public protector, we must be fair to the members of the committee, we must be fair to the nation entirely. So we must serve justice. I think since we've started this inquiry, we have been elaborate in terms of how should we dispense justice, in terms of how we are proceeding with the committee. So I want us to say things as they are. The public protector is not confirming if there is an official withdrawal of the legal team. And if that's what the public protector is saying, let it be on record that the legal team marched out. We must call it a march out, because it is a march out from proceeding. So we are all engulfed with that crisis. But I think part of what is important, Chair, is that let us, because the situation is with us now, after the march out. We must, of course, afford the public protector time to secure her own legal representation issues and ensure that when she comes back to the committee, she, in terms of the Constitution, the Constitutional Court order, and the Western Court High Court views and all that, she must indeed be represented in the inquiry. And there is no dispute about that matter. I want to move without taking much time, to move in support of, I had Honorable Ngozi and Honorable Manani talking about from now, 11:30 until 5 o'clock or whatever time later Monday, for her to secure these matters. But in that time, definitely she will be in contact with the chair or the evidence leader, so as to advise how far is she going in terms of
Setlatwala, you are disturbing.
Mase
Can you mute that, or we take him out? Apologies, Honorable Ngola, please continue.
Thank you, Chair. So I was saying, in the meantime, there will be a constant communication between today and later Monday between the public protector yourself as chair or evidence leader as to advise how far is she going in sorting out the issue. Otherwise, we are all chair. I'm sure no one is disputing that the public protector must be represented in the inquiry. But another thing, chair, that I think may have remember, we're all seeing another witness was in the proceeding yesterday, the whole day, and all that. Remember, there is still a pending cross-examination by the public protector. I think this time must equally allow them to prepare for that cross-examination. Then Tuesday next week, I don't know the date. It must be the 1st or the 2nd, I'm not sure, of November. Tuesday, we resume with witness Tejane for that cross-examination, then take Van der Merwe, so that we complete the first leg of leading evidence. Well, remember, we still have time, ample time, that we need to offer the public protector to lead their own evidence. And remember, we can't ignore, however we feel, we can't ignore the fact that the rules of the National Assembly instruct us, it's an instruction to conduct this inquiry within a reasonable time. Hence, we must balance the reasonable time with justice and fairness. So I'm saying, Chair, like I'm proposing and supporting those who have got the same view, that at least Tuesday, let's proceed in finishing up the first leg of leading evidence. In between, you would have been able to sort out some of the issues and brief us as the committee chooses. Thank you very much, Chair.
Thank you, Honorable Ngola. Honorable Nodada, are you back?
And that smoking is prohibited.
Am I audible, Chair?
I now ask you
Yes,
to please get into
yes, you are audible. All of you there, you are audible. I can see that you are at the airport.
Yes, Chair. Apologies for the background noise, Chair. Chair, I would like to make three very quick suggestions, Chair. I'm not going to go into all the details. I think some members have covered quite extensively, especially Honorable Dr. Lottridge. But the first suggestion I would like to make, Chair, is that we give the public protector until Monday at 4 o'clock to sort out her legal representation. The second suggestion I would like to make, Chair, is that the evidence leaders proceed with the last witness, as indicated that there's only one witness that is remaining that needs to be concluded in this regard. And then we know that what we'll have to deal with is the public protector taking through the cross-examination of the two outstanding witnesses and leading her own witnesses in this regard, Chairperson. The third thing, Chair, that I would like to suggest to you, Chair, and the committee as a whole, is that we get legal advice from an external source, an independent legal advice, as to what then transpired is in a situation whereby the legal representation of the public protector has then withdrawn. And if they do come back, what are the implications? If they don't come back, what are then the implications? I think these are the three main suggestions I would like to make, Chair, to ensure that we continue with our constitutional obligation of running the process, but also ensuring that there's fair and reasonable time in which we do so that the mandate that has been given to us constitutionally, we're able to exercise and execute within the time frames that is set for us, so that we don't find ourselves in a situation whereby we are not able to fairly conclude the process in a reasonable time. Thanks, Chair.
Thank you, Honorable Nodada. Honorable Mauta.
Thank you, Chair. Let me take this opportunity to greet the public protector, greet your good self, Chair, and the colleagues, and the evidence leader. Chair, I must say that it really doesn't matter how one looks at this issue. the public watching these proceedings, watching what was supposed to be a standard setting proceeding that is supposed to deal with section 194, turning into this is very unfortunate. But we are here because people could not rise above misguided and misdirected partisan mandate.
Honorable Mautwe,
Yes.
Honorable Mautwe, we're finding it difficult to hear you. Just get closer to your mic.
Okay, can you hear me, Chair?
Yes, that's better.
Okay, so let me start. I wanted to greet the Public Protector of South Africa. I wanted to greet your good self, Chair, the colleagues and the legal evidence leaders and the legal team of Parliament. Now, Chair, I'm saying it doesn't matter really how one looks at this. To the public that is watching these proceedings, watching what are supposed to be a standard sitting proceeding dealing with section 194, turning into this is very unfortunate. But you are here because people could not rise above misguided and misdirected partisan mandate. We are now finding ourselves in this mumbo jumbo mess that we are in. Now it looks like we all don't know what we are doing, or we cannot handle complex matters. Chair, it is your refusal to recuse yourself that has effectively rendered this whole process questionable. You allowed your emotions to cloud your judgment and made this about you. You would have not lost anything had you recused yourself. The less said about Mr. Melam, the better. I mean, his continued presence here, while his wife is going around telling Black people that they're uneducated without matric herself, something that we believe that she's telling her at home and is likely to be the same view. Just make mockery of this whole inquiry. And you allow it, Chair. Chair, you have already made it clear that you are not bothered that you and members of the ANC and the DA are going to be biased. The decision yesterday to refuse the application to postpone the inquiry until the application to challenge your refusal to recuse yourself just confirm to all watching that you are not bothered by what everyone thinks about your own biasness. We lose nothing, Chair, as a committee by making this process as fair as possible. But we are here now, and it seems that the events that happened in the past 24 hours are being treated with a shocking attitude. People are going up and down, forgetting even the basic tenets of natural justice, supported by our own rules of Parliament. I mean, Chair, this morning we listened to the Public Protector, who was given a very limited time to process what happened yesterday, let alone prepare a response to come here this morning with an expectation that she must be coherent, clear, and as practical as possible. How unreasonable can we be? The Public Protector did not withdraw her own legal representation. She said that many times. I don't understand why committee members are finding it very difficult to internalize this. The PP did not withdraw her own legal representation. She was equally shocked, like all of us, when they walked out. She never gave any instruction to her legal team to walk out. Now, regardless of their reasons, Chair, of walking out, despite whether they have merit or not, the bottom line is that they're not here, something she has got no control over. It is disturbing, Chair, that the legal department of Parliament and other members of the committee are willing to cast aspersions on the PP on events which she does not have control over. The least said about the committee legal service, Chair, the better. That's why we're losing cases in Parliament. It's purely this incompetence that we assist with today. Somebody comes with all the cases that are against what we are dealing with. What about the cases that are for? Why are you presenting such biased presentation to us as members of Parliament? You want to give us one-sided view so that we take that view as being the final view. It's wrong and it must be condemned. Stop wasting taxpayers' money. We're going to lose this. We're going to call Parliament. We're going to lose. We're going to look like idiots here. We are not part of this circus, Chairperson. We will not agree to this. I mean, she behaves like she's got some agenda from dark forces who want this process to be completed as quickly as possible. She comes here with aspersions that PP wants to drag this thing until the end of the term. Did we hear PP saying that? Why are we not being patient with the PP? She's exercising her democratic right as a citizen of this country. We must all be patient. It is the law that governs all of us, whether you like that law or not. But we are bound by that law. We made that law. Let her exercise her right to the latter. It doesn't matter how long it takes. It is justice at the end of the day. Now, Chair, Of course, she acknowledged that in her speaking notes that there's a lot of facts she does not have. But even with that, the legal the legal department of parliament, she continues and make a lot of conclusive statements. It would have been responsible for her to simply request time to consider all the facts and prepare a coherent submission and give us that submission to follow. Not something that she speaks on and we are now expected to be responding to it in detail or reject that. We must remember that, Chair, we're not here to represent ourselves, but we are here to represent the public. Chair, my proposal is that let's allow the PP reasonable time. Let's postpone and we'll reconvene when a public protector has established a representation clearly. This issue of giving her a Monday, what, we are already being unfair to her, Chairperson. She came here earlier on. Maybe some of you are not listening, some of the members are not listening. She says immediately.
Honorable Maute, are you there? Honorable Maute? Are you still with us? I think she's cut out.
Chair, sorry, Chair.
Yes.
Can you hear me?
Yeah, I can hear you now.
Where did you lose me, Chair?
Hello?
Where did you lose me? Where must I start, at Chair?
Your last point that we missed that part.
It's definitely not the last point. Chair, I'm saying that.
Yeah, it's a lot. It's not. Yeah, to me, it's the last point. It's not the last point to you because I can't see what you have. Please, go ahead.
Okay, Chair. I'm saying, Chair, my proposal is that let's allow the PP reasonable time. Let's postpone the sitting and we will reconvene when the PP has established representation clearly. This is not a challenge to the decision of the committee to postpone the inquiry. It's not. That one we are clear, Chair, yeah, that you want to remain biased. That's fine. We're okay with that. We've heard that. But the PP came here this morning and had already said that yesterday she called the director of Saneho attorneys and they agreed on the meeting either on Monday or Tuesday. I don't know where the committee members, who were they listening to? Because that's what PP said. You can go to the recording, Chair. That's what she said. She further went to say that she appeals with the committee members to give her until Friday next week or the Monday after. What is so difficult about accepting that, Chairperson? Why are we being so unreasonable to a poor woman, poor lady? You were saying to me, must not say a lady in the morning. Let me say the lady to the PP, because there's nothing wrong. Now, Chair, when the recusal application against yourself was presented here, you gave yourself a good 2 weeks to think about whether you want to recuse yourself or not. Yourself. Why are you denying the PP the same opportunity? Or is it a privilege that only comes with the chairperson and not extended to the PP? Why are we allowing that as committee members? All of us, we kept quiet when chairperson said, I will come back to you, committee members, whether I must recuse myself or not. It went quiet for a good 2 weeks. None of you raised an issue of saying, Chair, you are wasting time. We want to conclude this matter. But today, because the PP is asking for the same thing, you are saying that, no, you can't do that. That's unfair. That's how unfair this process is and unprocedural and biased it is. Chair, whether we like it or not, finally now, that's my last point. The Concord has ruled, and I'm going to read it word for word so that we can internalize this thing, and it must sink. The Concord made the following ruling. I'm reading now. Paragraph 118A, Roman figure 1 of the order of the High Court is amended to read. The phrase provided that the legal practitioner or other experts may not participate in the committee is irrational and inconsistent with the Constitution and is declared invalid. The proviso is severed from Rule 129 AD3. The amended rule now provides that the Section 194 committee, we must listen now, must afford the holder of a public office the right to be heard in his or her defense and to be assisted by legal practitioner or other expert of his or her own choice. That is what the Concord has said in this matter, not in another matter, in this matter. Now, if you all continue without giving PP the chance to get a legal representation and to continue without a legal representation, you will all be in contempt of court You run the risk of being taken to prison because you are stubborn and you have behaved like stupid. So we are not going to be part of stupidity ourselves. That's the EFF. We reject that. We must continue as the committee without PP having a legal representation. Let's afford her the chance to go understand what happened yesterday and get the new mandate and give herself chance to go. If he has to go look for another legal firm to get another legal representation and come back to the committee. I thank you, Chair.
Thank you, Honorable Moultrie. Honorable Violet Sewela. Honorable Sewela.
Thank you, Chairperson. Chair, without wasting any time here, let me appreciate the presentation by the PP as well as Fatima Abrams. But Chair, I want us to put it on record on the presentation by the PP. There is a sentence or a clause which I don't agree with, which says that the committee ignored or rejected or dismissed. We never ignored the presentation. What we did, we deliberated yesterday accordingly. At the end, as the committee, as a collective, we rejected and dismissed that application. We did not ignore it. I want that to be corrected. Secondly, Chair, I support the view that we give the public protector chance to liaise with her legal team. Chair, already we are running out of time. We have got other responsibilities in Parliament. We're not here only for this committee, so that should be taken into cognizance. I think we are patient enough, and in order to execute our duty as an organ which is doing oversight in Parliament, we are supposed to be given an opportunity to execute our responsibility at a reasonable time. I don't agree, Chair, with those other stories of delaying again this process. We have waited, I think it's enough. If I may be detained today, now, whether it's a Friday or a Saturday, I'm at liberty to can get a rep. So I don't agree with the notion of saying that we need to give the public protector a time. Time has been given. What is questionable now is the issue of the withdrawal of the legal team, which we are not in agreement with, and we sympathize with the public protector, and we are not going to force her to stand on her own. We are allowing her to go and consult, but it can't be long. I believe we need to proceed by next week as per our decision yesterday that we are dismissing that application based on reasons which were tabled yesterday. So we are giving her, we are requesting her, in fact, not giving her, we're requesting her, since she's saying she's ready to cooperate. That cooperation, we appreciate it, but let us not delay this process for too long, as one has indicated that the nation is watching us. So to avoid a lot of stories and delay tactics, we need to proceed by Tuesday. This committee should proceed accordingly. Thank you, Chair.
Thank you, Honorable Sewela. I now recognize Honorable Maneli. Honorable Boyce Maneli.
Honorable Chair, thank you. Honorable Chair, greetings to yourself,
Okay,
honorable
my
members.
apology. Just pause, Honorable Maneli. I'd forgotten about this like yesterday. I think because so that you can hear, don't want to you to miss out. Let's take a 10-minute break, comfort break. My apologies for that. We'll be back at 5:02. Thank you. Because if you leave, then you miss out from hearing. Thank you, PP.
Recording stopped.
Honorable Maneli, you are on the platform.
Thank you once again. Honorable Chairperson, greetings to honorable members and the public protector. Maybe let me start, Chair, before I make my points. Indicate that indeed, from where one is sitting, it is really unparliamentary for Honorable Mautwe to refer to members as stupids and idiots. And I would want that chair be withdrawn, as it is unparliamentary to do so. But I think more importantly, it's a point that says we should respect each other in the way we address each other as honorable members, so as for us to value every member's contribution in this committee. And I would want you to rule on that, Chair, because surely you would have also heard those words used by Honorable Maut. But that is just the point from a point of rules. But let me get to the real matters on the table, Chair. Firstly is to note a presentation that has been made by the public protector. But of course, there are questions that one may want to be clarified upon, Honorable Chairperson. And I'm doing this, of course, again, mindful of the fact that, yes, there is a court decision. And as we look at different clauses, we look at them comprehensively and together as one judgment. The same judgment allows that we ask questions directly to the public protector, as the right to legal representation does not prohibit members from asking those questions. I think it is at a point of answering those questions where a need for legal advice would arise, but other questions may need to be answered. And I'm only asking, Chair, clarity questions based on the presentation made. We may need to be clarified, and this is important for the future, so that if we have what Honorable Nola called a march out, we should understand how to react to that. If it is said that the mandate was, as it relates to the presentation or submission of the adjournment application, does that mean that there's a mandate for every sitting of the inquiry, or the services have been procured by the PPSA to deal with the entire inquiry? Now, this is important, Chair, from where I'm sitting, so that we know whether there would be any chance that if there were to be continuous march outs, are we going to be introducing new legal representatives all the time? And will that not border toward the case laws that have been quoted by Parliament Legal Advice would mean, where it would then border to deliberate collapse of a process in order to force an adjournment? So I think for me, it's an issue of clarity, because surely these services, there was a process to procure them, and there's a proper brief in terms of reference for such an appointment. But the second issue really, it's that from where one is sitting, Chair, we are no longer discussing a decision taken by the committee in rejecting that adjournment application. But in the main, it's about finally what we said was to be a committee that proceeds to do its work, and that you need to have a discussion with the public protector, evidence leaders, and so on, coordinated by yourself as the chair, to look at the operationalization of that continuity. And I take this presentation to be about that operationalization, and therefore indicating what could be challenges in proceeding or not proceeding. That's the first point. Second point, on that operationalization, it was also informed by the fact that there was a letter of communication which indicated that in a case this is rejected, would have proceeded even by yesterday in terms of the completion of the other witnesses, where there would also be evidence-led, but also where there would be a witness where the PP and her legal team would elect to cross-examine, or as they would have done before, indicate if they don't even think that there's a need to cross-examine given what they see before them. So at least on record, as such. So in that score, Chair, it would mean that giving extra days, it's about really getting the committee first to complete the other part. And as you would have done from time to time as part of that fairness, even when you have given the timelines, you would also agree that a situation will be assessed as we progress and make a determination at that point whether to allow extra time so that parties are able to exhaust all questions that they may want to still have or areas that they want to cover. So we've seen that happening in this committee as part of that fairness. So in this regard, Chair, I want to agree that on the first part, we allow indeed that consultation and resume on Tuesday, where we are able to get to the other witnesses. And surely at that point, there will be an indication even on how the next process would go of getting the witnesses, if the public protector so elects to bring those witnesses that would have been prepared to come and at least speak on what they are able to present before the committee, so that the committee is able to make informed decisions. So with that, Chair, I really want, as I said, if that question is not answered, I'm just worried that we convene next week. Then we have also a situation where maybe legal agreed and then from there another match out. And maybe the question I would have left, it's a point that's being made in the presentation, which seems to suggest that the PP will be also undergoing a process of persuading these representatives. And in a case that doesn't happen, you'd have to look at new legal representatives. Once again, as I said, it still brings the point, what were the terms of reference of appointing the attorneys who would then make instructions to the council. Maybe the last point is the point raised by Honorable Mananiso about the committee being undermined. If one has to take this submission, which confirms the verbal submission immediately made by the PP yesterday, that she was not aware that they would walk out. I think that's one. But the second one, Chair, was that even at the time you wanted to present the report of the committee, the attitude was that we have already heard what the committee says and has decided. We can as well respond. Of course, jokingly, you said you'll get back to the summary. But why am I raising the point? I'm raising the point, Chair, in that at that time, they were all absent from the sitting. And they were able to follow on this part and be able to craft a resolution immediately that would work out on the basis that the decision is against what we said would need to get as an outcome. And therefore, it will be reasonable for anyone to say that in proceeding next week, and there may not be representation, that argument can be still raised by others, that you are still able to follow, at least on record, and be able to make the review, which will in a way speak to what Honorable Mananiso would have asked about so many days that may be needed. If people at least have demonstrated the capacity yesterday, that you can be out of the meeting, you don't even need to be briefed by that meeting, you've made up your mind. So why I'm raising the point? I'm raising the point because some of the inputs begin to say we're not reasonable, we're pushing for timelines, we're pushing for all this, there's no justice in this. But the truth of the matter is that it is contrary to that. There's still time that gets afforded. And there was time afforded to even brief the team about the outcome. And before you even do that, they were ready to move on because they know everything that's discussed. And probably it's also a confirmation that there's nothing hidden. The public, which includes everybody else who follows the deliberations, it's able to know where we are, which will then mean that even reference to the number of pages and all that may not really stand chair if we have been following the discussions. So I don't want us to live with the notion that even with new representatives that may be brought in, because at this point there's no confirmation in any way that there'll be new representation, because there's still gonna be a discussion. There's nothing that says there's formal withdrawal, unless in the responses we'll now know that there's formal withdrawal from the process and there's a need for new representation. So I'm saying, taking all that into account, we should be able to proceed, Chair, from Tuesday with the evidence leading and so on. And as you usually use your discretion, assess how far we've gone on the day. And surely between the public protector and the leaders, there would still be a discussion on how the next level, which is that of affording the public protector the opportunity to also state a case and convince the committee why she would be exonerated and whether the matters that they've put before us, that everything else that has been said, it's really about the actions that the public protector would have taken to improve service delivery in that office in terms of the time it takes and all that. So we've been listening. And I think until we have listened to the public protector's side, Chair, that justice is still absent. And I want to say that the timeline must also be understood, that even a delay in dealing with the matter can also be construed to be denying the justice to the public protector of having the case being heard speedily, whilst the minds are still fresh and could be able to bring evidence that could still be listened to. I submit, Chair. Thank you.
Thank you, Honorable Maneli. Honorable Sukas.
Thank you, Chairperson. I firstly want to say thank you to the Public Protector for a submission, and then I want to start by thanking our legal advisor. And I want to say that, Chair, it is very important for us to not pay lip service to the issue of respecting women. And so I find it objectable that we can insult women in the way that we do, or any human being for that fact. But I think in light of the fact that this parliament, and certainly most parties or all parties, have made it their priority or their one of their key drivers to look after women, we should not come here and then insult professional women in the manner that we do. So I just want that to be noted, and I want to apologize to the legal advisor, to Mrs. Fatima, that she needs to hear that from public representatives that speaks to support staff in that manner. It is not, it's not okay. And in fact, I think we have allowed ourselves to be pushed to the barrier when it comes to how we handle people within the Parliament of South Africa. It is inexcusable for us to allow people to be treated, and ongoingly so, in this setting where their dignity gets damaged in that manner. I have a few questions that I just want to ask, Chair, if the committee can be given an indication on it. The first is, was already by Honorable Maneli mentioned, what was the mandate that was given by the Public Protector to a legal team, if we could get that, and whether, I think we asked it yesterday, whether the Public Protector instructed a legal team to withdraw. And then lastly, Chair, is there a breakdown in the relationship of the Public Protector and the legal team following their abandonment of their client yesterday, that certainly severely jeopardizes her in these proceedings? So I would like to ask that. And then, Chair, I just want to highlight the issue around that has been canvassed, I think, by two of Honorable Mulder and Honorable Lotrit, which is the fact that we need to proceed. I want to say, Chair, we are accountable to the people of South Africa. It is not a nice thing to say. It is the reality. And so is the Public Protector. Every single cent that is being spent here actually highlights the fact that poor people does not have recourse legally. It highlights the gaps, the inequalities that we actually fight for, or that we say we fight for. So in light of those things, it is not in the interest of the people of South Africa for us to further accommodate delays. And I think it is important for the committee to remember, as was set out by the legal advisor, the context within which the events yesterday transpired. We cannot ignore that. We cannot ignore that. And I think all the colleagues has already highlighted the fact, and yesterday, around the fairness of the process, the frameworks that are in place. We cannot ignore that. For any person to sit here and to say that, you know, that the process today has not been fair would be a total misstatement. We have a duty towards the people of South Africa, and we cannot allow ourselves to become paralyzed as a body that is meant to give oversight. We cannot allow ourselves to be paralyzed. And for that reason, Chair, I do think, and I want to say, we need to proceed with speed, as was said earlier, and that the committee cannot allow itself to further be delayed. This committee, lastly, consists of all the parties presented in Parliament. There is diversity here and a full representation that ensures balance. And it is most important for us to understand our obligation, not to our parties or to our interest, but to the people who actually puts us here in Parliament. Thank you, Chair.
Thank you, Honorable Sukas. Your last one, Honorable Gonde.
Thank you very much, Chairperson. Let me also appreciate the presentation from the legal services team. Chair, my inputs will not be long. I just want to ask the committee to call a spade in this instance. What happened yesterday was clearly planned, and as Honorable Ngozi said, it was clearly staged, Chairperson. We can't deny that there have been 3 recusal applications and the adjournment application yesterday. So there is a concerted effort, in my opinion, to actually stall or delay the proceedings of this committee. And I think it's time as a committee that we acknowledge that in as much as the public protector has rights, we also have rights as a committee, and we need to start looking into exercising those rights. The committee, I think I share the sentiments that the committee has been undermined in this instance. I mean, the walkout that we witnessed yesterday, it was unbelievable, but it happened, and we have to exercise our muscle. We are Parliament, and the public protector is ultimately accountable to us, and we have to hold her to account before her term of office ends. So, Chair, I think it's really time that we also sought legal advice around some of the rights that we have as a committee. I know that we have rights in terms of our rules. We have the right to summon anyone to appear before us. So we have to really start exploring our legal options as a committee, because we've been bullied enough and the situation has become, honestly speaking, untenable. And I want to repeat that we are Parliament, and we can hold institutions accountable. And in this instance, we've been charged with doing that. We have a mandate from Parliament. These proceedings are taking place on the premises of Parliament. They were initiated by Parliament, and I feel like we are being pulled by the nose at the moment, and I want us to get back our control as Parliament. And we can only do that if we exercise some of the rights that we have. Thank you, Chairperson.
Thank you, Honorable Gondwe. Just complete my time here. Thank you, honorable members. That was the last member for these interventions and clarities. I'm now going to revert to the PP, the public protector, to give you an opportunity to respond to the areas that have been sought for clarity. And they seem all to be centering in 1 or 2 areas. It's certainly not all over. And to help to have you put those on record, mainly in 2 parts or so, whether you can confirm in this meeting on record whether you, as the PP, you withdrew the legal representative mandate to act for you in this inquiry, or whether it was restricted. You issued a restricted mandate which was only limited to yesterday's application. And Honorable Maneli would have gone further to indicate that clarity is needed whether the mandate is per inquiry or per meeting, so that we understand if the terms of reference, that's what they indicate. I think that's a bulk of, at this stage, the clarity is sought, and there would have been others. I think the issue of the implication of the withdrawal, I'm going to ask, because it was directed to Ms. Ibrahim to speak to that. I'll go back to that for her to clarify. And thereafter, I will try and do my summary. The public protector.
Thank you, Chairperson. Chairperson, the input by the legal services, I wouldn't deal with that. That will be dealt with by the legal team, and if that can also be submitted in writing, because she raised a number of issues and insinuations, which some of them I think they would need to be dealt with legally. The questions by the members, I think I wouldn't deal with each and every member, because you will address that as the chairperson. Whatever explanation which has been said from the member Laureate Melder Nkosi Zungula, Mananiso Ngola, Notata Mautwe, Siwela Maneli, Sukers, and Gondwe. So I'm just indicating that I've noted all their questions and their concerns. But then for clarity, Chairperson, and as I've indicated in my opening, to be told that, and especially that I only have, but it's your decision, Chairperson. I would want the process to be fair. I was transparent, and I'm willing to address you instead of just keeping quiet and saying, I can't say anything. I don't have my legal team. I addressed you, and I'm saying, well, the operationalization, which was mentioned by Honorable Maneli, how do we operationalize this? The very same issues which transpired yesterday, and the fact that I'm saying I called the director of Siena for attorneys. I want us to go through all the correspondence and understand each other. What is our standing? I'm still saying the legal team has not withdrawn. So as far as I'm concerned, unless they have other intentions, but how do I speak on behalf of the legal team when they are not here? So hence the meeting with them, the attorney. After that, we meet with the legal team, the counsel team, and understand, are you proceeding or are you not proceeding? And even with the very same attorney. And I said it myself, Honorable Sukers, that I wouldn't want us to waste state resources. And indeed, if all of you are concerned about the public, which we intend or you intend to be protecting and saving costs, we'll have to make sure that we do not create instances which will lead the process to be taken further. I would want to discuss with them. I would want to avoid a situation where, what if I'm told, no, actually I'm withdrawing as an attorney of record. PP, go ahead and get another attorney. And if that is happening, I'll have to engage PPSA or Public Protector South Africa office and indicate to them, in your panel of attorneys, which attorney I'm comfortable to be working with, and that particular attorney as well, will I be comfortable if I approach the same legal counsel, because I think that's the legal counsel of my choice. So I think the main thing, Chairperson, is that can I be given that opportunity to go and engage and make sure that we agree? And Honorable Maneli is not per the issue, but as a team, we discuss and we prepare accordingly all the documentations which are there. And I think For the legal team, you'll have to ask them, Chairperson. I think there was a letter where you even wrote that they had the whole time when you had 3 weeks to decide. Why didn't they do the following? It's up to them to indicate, are they only focusing on this work, or they are proceeding with all their other work which they have or they had before this committee? Or because I don't know whether they were told not to do any other thing, as Honorable Melder is then now insinuating that the SC was sitting for 3 hours. I think that is for the SC to answer whether he must only not do any other thing. So I think I would say, Chairperson, can I be given an opportunity? Can I then clarify all these issues, all these letters and everything, and we agree with the legal team? I'm trying to avoid a situation where there would be a stage of starting the whole process of getting a new team and then proceeding with the new team. So I'll have to clarify all those issues, but still, Honorable Gondo, the issue which you are mentioning, that there is something which is staged or discussed, I think I wonder, well, it's up to the chairperson whether they would agree to that, but I think you'll have to have very concrete evidence when you make that insinuation. I wouldn't come here and want to be given an opportunity to meet with the legal team, and I'm trying by all means to make sure that the process is also not delayed any further. So, Chairperson, I would just stop there and say I would want to make sure that there is a legal team which will represent me, pay the Constitutional Court a judgment, and I think that's within my right to do that. And I think it must be very clear that we're dealing with issues of the principle of natural justice here. We're dealing with the issues of the fairness of the process, and the process must be seen to be fair. And if I feel as a person who is supposed to be accounting or responding to the allegations that I don't feel the process is fair, those issues should be raised. It's not an issue of just keeping quiet and not deal with the issues. And as well, raising issues while the process is ongoing, it's proper, unlike waiting until the end. And why do we have to as well expect the courts to resolve issues when some issues can be resolved besides going to court? I think yesterday I liked what the Honorable Member Nkosi mentioned, that did you approach the speaker? That's what we did, trying to avoid a situation where we must now rely and go to court. So yes, you've made your decision, and unfortunately there were not 3 applications. It was the application you considered. We then request an adjournment where we are saying, can we then lodge an application for review? So it was purely for that. But if we all want to proceed with the matter amicably, so then let's do that. Because on your side, you say you are not conflicted. On my side, or not conflicted, actually you are biased. On my side, I feel I'm not safe, or I feel that this process is not fair. Hence, then there are third parties who can then decide, out of all what has been mentioned, can you then go ahead and proceed or not proceed? But at the end of the day, I need to have a legal team to be with me, and so that we can proceed. So it's up to you, Chairperson, and the members, if you feel that what the legal services is even saying, that there are those 4 options and you might even proceed and do everything. So I think I wouldn't impose myself. The only thing I was asking are those dates, and I wouldn't want a situation where I'm being rushed, and then at the end of the day, the legal team comes back to me and say, actually, we are no longer proceeding. Start the process afresh and get a new legal team. Thank you.
Thank you, PP. Maybe just for the clarity of the chair, as I would be summarizing, am I hearing you correct that you did not withdraw the mandate? of the legal team?
I did not, Chairperson.
Thank you. And secondly, as you would have placed in your response this morning, you do confirm that in agreeing with what would have been in the application for adjustment, that the legal team was focused on yesterday's meeting. It was only for yesterday, as it would have been in the application, and as you repeated it in also your response this morning, that you agree with what they presented, that there was a particular focus for yesterday. Am I getting you correct?
Chairperson, I was just clarifying that yesterday, that was the main focus, but not only that.
Okay.
There were preparations which were done, and I think you'll appreciate that there are three councils. The other one might be focusing on this, the other ones might be focusing on all other things. But the issue now is, I don't know what's in their mind. I won't answer for them. I might be confident that I have not withdrawn them. And when I meet with them and we say with the attorneys, or even the attorneys will say, no, actually, you know, with what I've been going through as this attorney of record, you know, PP, I no longer proceed. So I don't want to preempt anything. I would say to you, maybe you need to then advise whether you are giving me that, or then if you insist that on Monday, I must come back, then I'll give you an output. I have to make sure then that I hope he's listening. He must avail himself at least by Monday. If you decide that by Monday, I must say anything. And hopefully he will be willing to continue with me.
Thank you. That's fair. Ms. Ibrahim, on the implications for withdrawal, that was a question directed to you.
Thank you, Chair. Chair, before I start on that question, I just want to clarify, because there seems to be a bit of confusion as to what my role is. I'm not employed by any political party. I don't work for any member. I'm employed by the Secretary to Parliament.
I will clarify that for you at the end.
But Chair, the reason that I say it is because it informs the nature of my advice. My role here is to ensure that this committee fulfills its mandate. That is why I'm here. That is the lens from which I give my advice. What I'm seeing now is somewhat of a sinking ship, a process that is being derailed. I'm doing my best on the rules and within the law, as I understand it, to assist the committee that it's not completely paralyzed. That is where my advice comes from. I have no personal interest in what the outcome of this process is going to be. In very much the same way, when we advise on legislation, we have no interest in what those policy provisions are. Our advice is on the law and the process that you need to follow to get to where you need to be. So it's on that basis that we're advising. That then leads me to a difficulty, and it leads me to Honorable Mananiso's question. She says, what is the effect of the walkout? Chair, at the moment, we don't even know what the nature of the walkout is, never mind the effect of the walkout. That simple information has not been given. I don't know if it is a walkout. I don't know if it was just in relation to the adjournment application. I don't know if it includes Sianejo and or the council or only council. I don't know where the instruction came from, if there was an instruction and so on. All of those are matters that would have informed our advice and that we don't have access to that. But I want to say this. It is true, the Constitutional Court has guaranteed that the public protector and all Chapter 9 heads must have the right to legal representation. But there's no obligation on Parliament to ensure that there's that legal representation. It is a right that the PP has. So the PP comes with her legal representatives. We've gone as far as we can to assist in that regard. We've on various occasions contacted the office of the PPSA to make sure that she's supported as far as that is concerned. If there is a question here of prejudice, that prejudice has not been occasioned by this committee. That prejudice has been occasioned by the PP's own legal team, which she appointed. So I just think that it's important that we change our perspective a little bit and that members understand the point from where I'm trying to advise. Yes, she does have that right. Yes, we're going to have to see how we deal with matters going further. But what I am trying to say now is in terms of the options given, let's see what we can do so that we don't completely derail things. Let us do the little bit of work that we can do in the interim, and then we cross that bridge when we get there and the PP comes back to us with more information, and that we also get the external opinion on what the impact is going to be if there is a completely new legal team now on the work that we've done. And in all of that, bearing in mind that this committee is constitutionally obligated to perform this function within a reasonable time frame, and that reasonableness is informed by what the PP's period of office is. For me, it's fairly simple, but I'll leave it at that, Chair.
Thank you, Ms. Fatima Ibrahim. As I go towards summary, just before I go there, I want to quickly have this clarity and check on the issue that was raised. I might have missed picking it up. Honorable Mautu, may I get your attention, please? Did you, in your contribution, made remarks about members being stupid and idiot?
Chair, I've said a lot of things. Maybe you can go to the Hansard to listen. I can't remember.
Honorable Maute,
Yes.
I'm asking a direct question. Did you make remarks that members are idiots and stupid?
No, I did not say members are idiots. I did not say that.
So it's not correct what is being alleged about you, that you would have referred to them as idiots and stupid.
I did not say members are idiots.
Okay, help me. What did you say?
Chair, I can't remember, but I did not say that. That is for sure. I did not say members are stupid, but I can't remember. I'm saying to you, Chair, help me so that I can help you. Go to the Hansard and listen, but I did not say members are stupid.
Okay, thank you, Honorable Maute. There are two things we're taking out of this. So I would have asked you a direct question, whether you did say members are stupid or idiot, and you clearly saying to me you did not say that. I'm going to have to verify that further for myself as somebody presiding in this. Would have to come back, make proper ruling, and if there is a need that the matter gets to be referred where it's supposed to be referred, that's what I'm going to do. But I first needed for you to help me confirm on record whether this is what you said or not. We will leave it there, and I will take your advice of going through the recordings and checking that, and I will do that work. Thank you. We leave it there, that matter. Members, I think, firstly, as we go to the summary, perhaps the matter would not have been explained properly yesterday, because I want to start with the role of the evidence leaders. When we designed this process as this committee, that we have the rules of the NA, but we also have the rules that are specific to this section 194, we agreed on what we called terms of reference. Those terms of reference, we designed in it a hybrid process. Would have discussed whether this should be just a member-led process in terms of just our normal oversight. And we settled on saying we want that because members, this is their constitutional responsibility, they are elected for that. But we then augmented that role with what we then called the hybrid process of having the external expertise in the form of evidence leaders. And so they are part of this committee in terms of its work. They are not prosecutors, that must then relate with a defense on the other side. If somebody wants to understand them in that way, it will be a wrong way to understand them. They are here to guide the committee, to assist the committee to get to the bottom of everything else that we do. That's the reason they would lead evidence. It's the reason that they would ask questions in relation to what evidence would have been led. It is their role. So I thought I wanted to explain that myself and not you, based on in the manner where the architecture of this process has been agreed. And I'm hoping that that question about your role and what you can say and not say will be settled, because from the very beginning until the day we conclude that report, they will have that role to play, because it's content driven. It's about the issues, about the findings that we must do either way. So I'm hoping that there's going to be no board who has a discomfort going forward about I would actually want them to play that role more vigorously, perhaps than they do now. I sometimes think that they're a bit withdrawn. So I'm challenging them to be even more upfront to help the committee, especially as we get into this stage. So that's the first point I want to make. Secondly, again, this issue needs to be clarified. We are an institution, the National Assembly. We besides what comes out of the Zondo report, you would if you go to the Nkandla judgment, this institution did not come out smelling roses in terms of its role, its integrity, in terms of how it exercises its functions. And Parliament and the National Assembly is on a continuous role to improve the way we do our constitutional functions of oversight. And so in this institution, you've got these elected representatives who rely on that technical capacity in whatever form, be it content capacity on a various subject, because they are part of the furniture of the institution. They must never be seen, because I kind of picked this up yesterday, that somebody thinks that they are an opposite of the PP legal team. They are not. So let's put that to bed and clarify that they represent us. We would want sharpness of ideas and advice. If members feel that in many other, because for this committee work, since its inception, I have no feeling that we have not been provided proper service. I have, as a chairperson and members have confirmed as such, we have been very impressed. So if there are other issues or concerns that we would have picked up in other areas, they must not be brought into this about the concern that members have about the quality, because this thing has been raised, quality of service and or advice and so on. We have none of that in this committee up until today. In fact, we've been well led, well advised and guided. You only have to look back in terms of the processes that we had to navigate to understand that picture. It's not something personal, but that's what it is. So I think it's important that Ms. Ibrahim, you continue doing your work without fear, without favor, because your role is about ensuring that this institution is not found wanting in the kind of advice that you provide. And I'm hoping that too, we're not going to be coming back to that and raising those kind of issues that we're settling on that matter. Let me move on that. I think colleagues, having listened to the PP this morning in her presentation, the legal advice, guidance, and raising sharp issues as they should be, and the contribution of yourselves as members, I think that it is fair to summarize our discussions in this manner. That one, that the committee in your deliberations and discussions accedes to the request presented this morning that we should not proceed with today's meeting in terms of what it was planned. And we accede to the request by the public protector would have indicated that by Monday she would be to a point of concluding whatever discussion that she would have. Many members have gone for option 2 to say this committee must resume as from Tuesday, to allow the public protector that space. While it might not be the space that 100% she would have expected in terms of the timelines, because she would have indicated that she would have been ready by Friday next week, or in the worst case scenario that week, but that by Monday, from her own presentation, she would have concluded that discussion with the legal team. And I therefore think that it's fair to summarize that that's our expectation. We want to go with option 2, that want to resume the hearings as from Tuesday in relation to both issues, the cross-examination of the outstanding witness, or the leading of evidence. Okay, let me correct myself. The leading of evidence of Mr. Niels van der Merwe as a committee. And what it means is that they would then, after Tuesday or Tuesday and a half, depending how much time we take for the leading of that evidence. I'm not going to ask that for now because somebody might be bargaining for more time. After we have led that evidence, then we'll be left with then 2 witnesses to be cross-examined thereafter. And so I think that that's, if I'm hearing the members correct, that's where the substantive and majority of views is anchoring on. Secondly, an issue has been raised that, and I think from the chair, we'll have to take that responsibility with the team, the support team I work with, that there is a further need. The public protector has confirmed that she has not given a mandate for the withdrawal of the mandate. But I think there's something hanging that I would need to understand, and Honorable Melder would have suggested that we need to further investigate this possible termination or whatever it means to understand and get to the bottom of that. I think you also would have you listened to a different other view, which says, in fact, before I get to that view, is that I need to confirm that this committee has sought legal advice and it got it in relation to these issues. If there seems to be members who think that they need a different and further legal advice, this committee has not resolved on any further legal advice. We had with the legal advice that we got in relation to these issues of recusals and so on. It doesn't stop any member or party that wants to satisfy itself with a further process. The issue of the reasonable time that has been requested, I think reasonable time here has got to be understood within that context of that Concord judgment on moving with speed without delay, because reasonable time and fairness must not impinge on the rights of the public protector, must not impute on that office, but also this institution as well. So we've got to balance all of those kind of issues. So I think those are the few things I would have picked up in terms of the summary of our discussions this morning. There being no further any other issue at this point, may I check quickly from members if that summary is in agreement with you and whether you support that as our decision of the meeting today. And quickly,
Chair.
any member can assist me.
Yeah,
Honorable
Chair.
Melder, Honorable Melder, I've just noted Honorable Melder, I'll come back to you, Honorable Bautu.
Okay.
Honorable Melder.
Honourable Chairperson, no, that was just a thumb up that says I agree with your summary. I think you've summarised correctly the position. Thank you.
Thank you, Honorable Member, confirming that this is the accurate reflection of your discussions. Honorable Mautwe.
Yeah, no, thank you very much, Chair. Chair, you did not take our inputs into consideration. You spoke about everybody else except our inputs. So I don't know how you missed ours. Ours is to say that when you were faced with the recusal application, you gave yourself 2 weeks. So can you afford the same privilege, if it is a privilege, to the PP as well? Seeing that the PP has already said that she's meeting a legal team on Monday, and then she had asked for Friday or the following Monday. So please take that into account when you make the ruling. I've not heard your ruling, Chair, but I'm just saying in your summary, you did not state any of the things that we had proposed and raised. And that, Chair, we will continue to criticize legal services of Parliament. We will. Nothing will stop us from criticizing it. If we feel that it's biased, we're going to state it. We're not here to, if people are not radical,
I heard you.
so
Thank you,
you are
Honorable
radical
Mautwe.
like that. We can't be told, otherwise they must give us the notes of what to say then. We can't be told what
Thank
to
you,
say. We
Honorable.
want to say exactly what we want to say, the way we want to say it.
Thank you,
They
Honorable
are
Mautwe.
biased. As it stands now, Chair, they are biased and they must be told.
Honorable Mautwe, I'm asking you to stop. Thank you. I've listened to you. And I think my summary would have taken into account the points you've made, both yours was, and Honorable Zungulu was to emphasize on the reasonable time that needed to be given. The ruling has been made, having listened to everybody else, that this Section 194 inquiry will resume as from Tuesday. That's a ruling that has been made. You might not be happy with that ruling, but it didn't mean that I've ignored the points that were placed either by yourself or any other member in this regard. Before
Please note the objection, Chair, for the record. Please note the objection of the EFF to that ruling for the record.
Thank you, Honorable Mautwe. That objection is noted. Advocate Bauer.
Chair, just for some clarity in respect of what is to happen next week, so that we're all on the same page. The Public Protector has made it quite clear, and she is the client, that she did not withdraw her legal representative's mandate, which effectively means that Sienego, to all intents and purposes, gave Advocate Mpofu a mandate which he was not authorized by his clients to make. I think that the Public Protectors made clear to us. She also indicated, pursuant to your question, that she did not restrict the mandate of her legal representatives yesterday only to the interlocutory applications. If I got that wrong, then Public Protector must please correct me. So as such, she's indicated that if the committee indicated she must revert by Monday, she would do so. And she's also asked that Ms. Ibrahim's submissions to the committee will be dealt with by the legal team. Is there a timeline by which that is to occur? Because I'm not sure the certainty of the legal team. I don't want the legal team to come back and say they need time to deal with Ms. Ibrahim's submissions when we don't even know what the position of the legal team is, and then next week we have another delay. So I don't know if we must get clarity from the Public Protector as to precisely what she wants.
I'm slow wanting to get that clarity because I seem to be clear that the committee is resuming on Tuesday, and the expectation that the Public Protector must be here when we resume. I have noted that request I should have made but Ms. Ibrahim was making a presentation here to the committee, because I don't want to create new hurdles and obstacles to our way forward starting from Tuesday, unless I'm not getting you properly.
No, I just want that to be clear so that it's not left in the air, that there is a right to reply to Ms. Ibrahim's submissions that you had not, or that the committee had not heard the public protector on. So if the ruling is clear, that doesn't exist, then that is fine. And finally, can we get some guidance? Is the public protector to revert in writing on Monday afternoon and we're resuming in person on Tuesday? Is that how next week will work?
I didn't want to go to those details again, but let me hear what honorable members are saying.
No, Chair, on a point of order.
Yes, Honorable Mautwe.
I don't know why you've opened the floor again. You made a ruling, Chair. When once your ruling is made, we move on. Why are you opening the floor again for Ms. Bauer now to speak? And now we are opening it for the members. No, Chair, you made a ruling. Let's move. You said your ruling is that we're resuming on Tuesday. All those nitty-gritty small little things, they can be discussed by your office. Please, let's move.
Okay, thank you, Honorable Mautwe, for your point of order. I get your points, Advocate Bauer. I think those would be matters that we must attend to ensure that the resumption is enforced. I'm just avoiding us getting into those little details now in the meeting, if you are okay with that.
Sorry, Chair, it was a point of clarity so that we don't leave here with some uncertainty as to what is to transpire next week. But if you're happy for it to be dealt with off the record, then that's fine.
Thank you. Thank you, colleagues.
Thank you, Chairperson. Have a nice weekend, everybody.
Thank you, Chair.
Physical attendance lunch is served at